A Los Angeles jury has found Meta and YouTube liable in a first-of-its-kind lawsuit that alleged the platforms knowingly made their services addictive and harmful to minors. After a 6-week-long trial, the jury voted this afternoon to award the lead plaintiff, identified only by her initials, KGM, $3 million in damages. Meta is being held responsible for 70% of that, and YouTube is on the hook for the remaining 30%. KGM testified that her early use and addiction to the platforms contributed to ongoing mental health problems. Jurors also heard from high-profile witnesses, including Meta CEO Mark Zuckerberg, the head of Instagram, and the vice president of engineering at YouTube. Speaking outside the courthouse today, KGM's lawyer discussed the message that today's verdict sends.
We've sent a message with this that you will be held accountable for the features, regardless of whether the children are getting sent pornographic pictures, regardless of whether they're being sexploited, regardless of those types of issues. Just because of the features alone that drive addiction, these companies can be held accountable.
Several parents who say their children have been negatively affected by social media also spoke out outside the courthouse.
For them, for the big tech executives, I want to say something. Stop blaming the parents. It's on you. And this is what this is showing today. And for parents, we now know that they were manipulating our children for profits while we were watching and trying to keep our families safe.
In a response to today's decision, a Meta spokesperson said teen mental health cannot be linked to a single app. The company plans to appeal. CBS News contributor and Loyola Law School professor Jessica Levinson joins us now. Jessica, always great to see you. A landmark decision today. What kind of legal precedent does this set for similar allegations against social media companies?
Well, I think what we see here is a potential roadmap for other plaintiffs to try and bring the same theory here. Now, before this case, social media platforms and internet platforms had said, we're protected because what you really don't like is the content of what you're seeing, and we're protected under Section 230 of the Communications Decency Act. What this case did is it brought a different theory. It said, we're not suing based on the content of what you see, but as we just heard, based on the features, the infinite scroll, the automatic play. And so to the extent that this jury is a bellwether, that this is a bellwether case, I think what we're going to see is other plaintiffs bringing very similar cases and hoping for the same outcome.
There are so many people hopeful that there is this movement pushing for accountability right now. But what could an appeal look like in this case?
So I think an appeal will focus on actually what we just talked about, the idea that the plaintiffs had this theory all wrong. And in fact, that the defendants are protected by Section 230 of the Communications Decency Act. That very briefly says that social media platforms and other online platforms can't be liable for the content of what other users post on their platforms. That they're essentially just a town square allowing you to speak, but they can't be liable for what's said in that town square. So I think that'll be their primary case on appeal, their primary theory on appeal. I also think that they will bring, related to that, a First Amendment challenge. I think that they will also say that there's an issue with causation. And you heard that a little bit just now, where the argument will be mental health is so complicated, you can't point to one thing and say, it's Instagram, it's YouTube. That's what caused the mental health issues here.
All right, Jessica Levinson, thank you.